Great to see everybody. I'm delighted that you're all here. Those of you who don't know me, my name is Professor Kasomanakis, and I'm the faculty coordinator of the Business Society. I also teach accounting. If anybody's interested in taking any of my accounting classes next semester, by all means, you're welcome to take them, but I'm tough. So anyway, I wanted to let you know that this is the last meeting for the semester, but we will be having we do have a lineup for the spring semester. So do check out your Tiger mails for the announcement, and some of the topics that we have will include e-commerce. We're going to have a speaker from the Small Business Administration talk about that. If you're interested in doing business online, this is a great opportunity to come and find out how you can set yourselves up and any other information that you may need. We also have another meeting on the new Health Reform Act and how it affects students, college students. So we're going to have that in sometime in April, I believe. I don't know exactly the dates. And also, we're going to have another meeting on eligibility requirements. So those of you who want to go to Baruch or to Queens College, this is a great opportunity to come and find out what are the requirements to transfer to those two colleges. So again, the announcements, you will get the information, the announcements by way of email. So check out your Tiger email address. It's very, very important. All right. I want to start the meeting, like I said, and I want to introduce to you our speakers. We have two speakers today. And our first speaker comes from the business department. And he's a certified public accountant. And he's also a certified mortgage banker. And he is a licensed real estate person. And he teaches the accounting classes. And also he teaches tax class as well. And his name is Professor Ben Morallo. Let's give him a nice round hand of applause. And our second speaker, he is an attorney. And he also teaches law and I think finance as well at the business department. So let's hear a nice round hand of applause to Professor Rosen. Okay, so let's start.
Thank you all for coming. Bernie Madoff has made history, unfortunately. He's infamous. I just want to start with reflecting in my research what happened, because the more I got into it, the less I understood, I should say, because as you recall in Accounting 1, we talk about reasons for fraud and things like this, like financial pressures, rationalization, and opportunity. But Mr. Madoff really didn't, he had a successful business running as a broker-dealer, handling more than 5% of the volume of trading through time. So very comfortable lifestyle, and there was none of these were really apparent to me. So a lot of the things I'm going to talk about today are going to be speculation, because nobody knows exactly how much was lost, when he started this, and how it happened. But I need you to understand that. So the first step of the talk is going to be a little bit about the history of his firm. And Madoff Securities started in 1960. Bernard Madoff is from Queens. He started as a broker-dealer, and he handled trades. He grew the firm handling, like if you bought a stock, he would execute that trade. Then he got into a little niche. The niche product that he did is he handled the electronic trading. He was a pioneer in e-commerce on the stock market, and he dealt with that so much so that he was handling, as I just said, more than 5% of the daily trades or order flow. What he did and how did he do that? Normally on a trade, when it's executed, if you handle the trade from another broker, because one thing I want you to know, Mr. Madoff handled other brokers' business. So if they had trades, they would come to him to execute them. Why did they go to him? Because normally a trade execution costs approximately 12.5 cents a trade. He wisely reduced that a couple of pennies. So it was, let's say 10, sometimes as much as 2 cents a trade. So he would go, he played off of other brokers' need for profit. So those 2 pennies each trade would go into the hands of the brokers that executed the trade through him. So now he's handling all this business. And one thing I want to throw out there, because he's handling so much of the order flow, he kind of knew what was hot as far as a stock goes and what wasn't hot. And you and I might read into that as something called insider trading. That's never been anything about today, what he did, but he did have information to see what the brokers were advising their clients throughout the process. So I just want you to understand that. The next thing I wanted to talk about really is, does anybody here know what a Ponzi scheme is? Anybody? Yes. Speak a little louder, please. Here. When you rip people off for billions? No, but my question is, how did he do it? Okay. Yes, guys.
Isn't it like when you collect money from individuals and you take that money and give it to...
But why is he collecting the money? Gentleman in the back there? Well, he promised unrealistic profits, being a Monday morning quarterback. He was saying numbers that were much higher. Young lady, did you have a comment? Thank you. Right. So first thing we got is he promised unrealized profits, high profits, unrealistic profits. And so he was playing off of his clients' hope to get a higher investment return than you would get elsewhere. So that may be considered their greed. So, it takes two to tango. I'm not saying that these people he did do something illegal, but he did play into somebody wanting more than the average person. Which, what is this, there's a saying, but I'll save that for later. Okay, a Ponzi scheme, though, is this. Not only is it getting unrealistic profits, you have to gain feeder money from other people to make it continue. Why is that? Because if I get your money and I invest your money and then you say you want your money back, I'm returning your money by taking his money and giving it to you, plus the profit. The profit that Mr. Madoff promised people was 1% a month or 12% a year. Now, in the world of the S&P 500, you can have some years where it's 20% and some years where it's minus 3%. So 12% is in the middle, which a lot of hedge funds and other brokers like and say that's okay. But the unique part about Mr. Madoff is that for a 7-year period, he literally only had 3 down months. So later when I read the book by Mr. Markopoulos, who was the whistleblower, he said, I saw a graph. Everybody knows at a 45-degree angle. The graph went like this on the returns of Mr. Madoff on a 10-year period. He said, I just looked at he's a mathematician, a quantitative analyst. He said, just looking at that graph told me that I have a fraud. This is unreal. I don't know how he did it, but there's something wrong mathematically. I have some specific numbers. I believe in 1993, the S&P 500 returned 1.33%. Mr. Madoff returned 14%. In 1999, the S&P 500, I believe, did just over 20%, and Mr. Madoff did 16.6%. Now, he was always in the game, and it looked okay, but never the beauty of it was consistent up. So how did he get caught, or why did this last so long? Let's talk about why did he get caught. His competitors said to this Mr. Markopoulos, who was a quantitative analyst in a company, they said, this guy Madoff's got something great going on. I want to copy him. Make this happen. Can you make this happen? And that's what he did. And he looked at it, he said, there's no way this guy could do this. I'm trying all the numbers, and he did. And then it manifested into something where he was a whistleblower with the SEC, which I'll talk about a little later. But what I'm just trying to say is his competitors started to question it. So initially, unrealistic profits. Mr. Madoff then made it somewhat secretive, private. If you were inquisitive, he would kick you out. He'd literally say, I don't want you asking questions. You got any questions? I don't want to talk to you. You're out. So people were like, I don't want to do it. Then you have to have feeders because, like I said before, if you want out, I have to use somebody else's money. He had a lot of feeder funds. What were the feeder funds? He used hedge funds. Other brokers would collect money from investors and then would come to him with their money. So those investors were literally paying double commissions, Technically, they were paying a commission to their original broker, and then they in turn invested it with Mr. Madoff and did that. Now, you would say these funds are required to do something called due diligence. Does anybody know what due diligence is? You just look into the quality of the assets. Each firm is supposed to give out something called a prospectus. And you get this prospectus and it tells you what we invest in by industry, what our returns are historically, and it tells you what's going on. And you're supposed to do some due diligence to verify if these numbers make sense. Like if it says Con Edison stock, what were the returns? You just look it up on Google and you could verify what he's saying on the prospectus or the firm is. Well, the due diligence by some of these feeders were poor at best. One French aristocrat, who later committed suicide, literally did a handwriting analysis on Bernard Madoff. That was his due diligence, which I'll ask Professor Rosen, is that acceptable in a court of law? Not. Graphology is not allowed in a court of law. That was his due diligence. Another person said they did nothing. They admitted. And they had $3.3 billion of their clients' money in Mr. Madoff's thing. Could you hand out the list of investors, please? We have here a list of the investors. It's a 163-page report of people that invested. Does anybody know what an oxymoron is? Do you ever hear the term jumbo shrimp? That's an oxymoron, jumbo and shrimp. Well, Mr. Madoff now created an oxymoron of his own. A sophisticated investor is the term that they're calling an oxymoron based on what Mr. Madoff did. And that's not really funny, but it's sad. Just give me 1 second. I want to make sure I told you that. So I explained to you the unrealistic profits. I then explained to you that he was secretive and he cultivated privacy and a steady return. Then the big thing I want to talk about now is in 1990, he then became the chairman of NASDAQ. And then whenever the SEC needed an advisor on an advisory committee, very often Mr. Madoff was asked to speak or be on this committee. They even created a rule called the Madoff exception based on his name and his ability to be able to buy certain things. I don't want to get into how stocks work, but the business of broker-dealer, but he was allowed to sell short in certain instances. Anyway, now we get into a little bit of Mr. Markopoulos' mathematical analysis. Could you go to slide 7? I'm jumping around because most of this is in my head, and I just want to talk about something called a split strike conversion. This basically what I'm going to explain to you right now is something called a hedge fund. You're going to learn what a hedge fund is. This is a strategy, a split strike conversion, and then it's explained right on the PowerPoint up there. There's a basket of 30 to 35 blue chip stocks that emulate the S&P 100. The blue chips are the best companies, General Electric. We have statements. You want to hand out the statements and let them see? This is literally a November 30th, 08 statement. Thank Professor Rosen for getting this on Google. No names on it, but it'll show you the stocks that were owned. And you probably heard at least of 3 of the companies on there. So we would get those stocks that had, usually these are companies that had very steady returns. Then we would protect them with puts and calls. Does anybody know what an option is? Just a brief understanding of it. An option is the right to buy a stock. A call option is you're betting for the stock to go up. A put option, betting the stock to go down. So what he did is he had calls and puts as a hedge against his bet. Let me give you an analogy. You bet on the favorite on the horse. Well, you really want the 50 to 1 odd horse to win. But just to cover yourself, you take the favorite on one side, and then you take one in the middle of the road. Is that kind of a good example? I'm making this up off the top of my head. But what I'm trying to tell you is he hedged his bets. And what does this strategy means in all, the bottom line is this. Is this limited his high profits? But more importantly, what a hedge fund does is it limits your losses on the put side. So once you reach a certain level, the put, and these are what are called covered calls. A covered call means you're using the money that the people have with you, not your own money, to do these option buys and sells. And what you're doing is because you're limiting your gains and your losses, there's only so much you can earn. So that further created an inquisitiveness in Mr. Markopoulos' book, No One Would Listen. Then he did interview several of the feeder firms. One of them was the Fairfield Group in Connecticut. Had billions of dollars also with them, and they too did a poor due diligence, which they're required to do on their statement. So anyway, everybody was moving along. People are taking money in and out. Why didn't this get caught? Because of his prominence. Whenever he was questioned, Mr. Markopoulos even went to the SEC. When he went to the SEC, they looked at, basically they didn't even know there was a 17th floor in the Lipstick Building. And the 17th floor was where all of this activity was really occurring. The 19th and 18th floor was the normal broker-dealer. It was on the 17th floor where he had about 24 employees and himself, and nobody knew, not even the employees knew, what was going on the 17th floor. I'm told, based on the book, that the SEC didn't even know there was a 17th floor. And then after 2 times of Mr. Markopoulos going to the SEC as a whistleblower, risking his life, I might add. I don't know if you've heard some stories about whistleblowers. They meet not such nice fate during the process. And he was in a very nebulous, precarious situation, I guess would be the word. And he didn't know what to do because he was asked to do it a 3rd time when the chairman of the SEC switched. There was a new chairman chosen, and they said, do it again, Harry, Mr. Markopoulos' first name. Please try to represent the whole details. They gave him, he basically laid out a fingerprint of exactly how this was done. Then, in the end, in 2007-8, everybody knows what happened with the mortgage crisis and the economy as a whole. And what happened is there was a run on the bank. And I believe at one day it was like $20 billion called. And unfortunately, the feeders were so big, but not that big. And that's how it came about, where he fell. So there's 3 ways a Ponzi scheme can go down. 1, the people that are running it abscond, vanish. 2, they run out of money. And 3, they go to the authorities and tell them. Does anybody know what happened with Mr. Madoff? No. He had his 2 executives, his son, go to the authorities and turn him in. And he did that probably just before what the young lady just here said. He was going to run out of money. And they apparently had this all planned out. Then the rest is well documented in the newspapers of people, prominent people who invested, the Mets owner, Wilpon family, other movie stars, Mort Zuckerman. You would think, sophisticated investors, but unfortunately, the bottom line for me to you is if it's too good to be true, it usually is. And at this point, I'd like to let Professor Rosen explain to you the criminal aspect of this, the liquidation and bankruptcy proceedings, and various types of litigation. Thanks. Any questions? I'm here at the end, too. Thank you.
Thank you. Thank you, Professor Merola. I just would like, as my colleague said, describe three different aspects of the legal proceedings. Can you hear me without the microphone? Maybe I'll try without the microphone. If you have trouble hearing me, just leave. On June 29, 2010, Bernard Madoff was sentenced in federal court in Manhattan by U.S. District Court Judge Denny Chin to the maximum 150 years for what the judge called, quote, extraordinary, evil, close quote, fraud that shook the nation's faith in the financial and legal systems and took a staggering toll on rich and poor alike. Now, this sentence came just 6 months after, as Professor Merola said, Madoff allegedly told his sons that his entire business was this massive Ponzi scheme. The penalty, when it was announced in court by Judge Chen, produced applause from the audience, many of whom, probably most of whom, were victims. At one point in the sentencing procedure, Bernard Madoff turned around to the victims and he said, quote, "I'm sorry, I know that doesn't help you." Later on, he told the judge, quote, "I cannot offer you an excuse for my behavior. How do you excuse betraying thousands of investors who entrusted me with their life savings? How do you excuse deceiving 200 employees who spent most of their working life with me? How do you excuse lying to a brother and 2 sons who spent their entire lives helping to build a successful business? How do you excuse lying to a wife who stood by you for 50 years? The same day, in the same court proceeding, or earlier in that proceeding, Bernard Madoff, through his attorneys, stipulated. And what stipulated means? Who knows what stipulated means? I see some of my former business law students here. Stipulated means agreed. He agreed that the government, if it went to a hearing on its claim that Bernard Madoff's assets should be forfeited, he agreed that the government could prove that he, Bernard Madoff, would be liable for a personal money judgment in the amount of $180 billion. He also agreed that the government would be able to prove that he would be liable for a second money judgment in the amount of only $799 million for money laundering. Based upon his agreement, there was no hearing. The federal judge, Judge Chen, basically directed that a money judgment be entered against Mr. Madoff in the amount of $170 billion, and that a second money judgment be entered against him in the amount of $799 billion. He also directed that virtually all of Mr. Madoff's assets, and there was a long list attached to the judgment, a long schedule of assets, but virtually all of his assets be forfeited to the United States. What does that mean, forfeited? The government takes over ownership. And this is all by stipulation. He didn't fight this. He could have required the government to go to a hearing to prove this. Forfeiture comes in when a person commits a crime, especially a federal crime. The government oftentimes will go to court to start a forfeiture proceeding to basically take title to the property that was acquired through the fraud, through the crime, on the theory that you cannot keep the fruits of your crime. So if you commit a crime and you acquire an expensive boat based upon what you make through the crime, the government can come in and take over the boat. Now, as I said, Bernard Madoff was sentenced to 150 years in federal prison. You should know that there is no parole in the federal courts, in the federal prison system. What does parole mean? Parole is when you get out of prison early. In New York State, we have what's called an indeterminate sentencing system. Somebody maybe convicted of armed robbery might be sentenced from 10 to 15 years and would be eligible for parole after 10 years. If he meets the conditions, if he's a good prisoner, he might get out early. Not so in the federal courts. If you're sentenced to 150 years in prison, you serve 150 years. With one exception. He's entitled, as any prisoner is, to 15% off for good behavior. So that brings it down to 127 years, if you were to qualify for good behavior. In addition to that, on each of the 11 counts, there were 11 counts against him. In addition to the sentence, there was 3 years supervised release, it's called. So if he were to get out after 127 years, he would still be subject to supervision for the next 33 years. So I want to talk about, in a little bit more detail, the criminal charges. I want to talk about the liquidation proceeding and the bankruptcy proceeding. And I want to talk briefly about some of the lawsuits. There are many lawsuits that have been started, or a number of lawsuits that have been started, and more will be started by the trustee in the liquidation and bankruptcy proceeding. When Mr. Madoff was arrested in December of 2008, he was originally charged with 1 count of securities fraud. That was done very quickly after he was arrested. And then a couple of months later, in March of 2009, after the government had a chance to investigate the matter further, they filed what's called a criminal information. And they alleged 11 counts. The first one is securities fraud, and that's the main one. And that goes into basically what Professor Merle described, what he was doing with his investment accounts. The second one was investment advisor fraud from at least the 1980s through December 11, 2008. That's the day before he spoke to his sons, I believe. Madoff acted as an investment advisor for clients of his firm and employed devices and schemes to defraud clients. Count 3, mail fraud. Mail fraud is a federal crime. If you use the mails to commit a fraud. And that count alleges on December 1, Madoff caused to be sent through the U.S. Postal Service a false and fraudulent account statement. Now, obviously, he would send out many, but the government just picked out one. That's all they needed. False and fraudulent statement from his firm to a client in New York. Count 4, wire fraud. August 5, 2008. Madoff caused $2 million to be wired in investor funds from Bloomington, Minnesota to New York, across state lines, electronic transmission. Count 5, international money laundering to promote specified unlawful activity. From 2002 to 2008, Madoff caused the transfer of funds from his firm in New York to a related firm that he had in London. And then from those accounts in his New York firm to other accounts in New York. The money was derived from fraud in the sale of securities and theft from an employee pension plan, employee benefit plan. This is money laundering. The claim here is he sent money from his firm in New York to an affiliated firm that he had in London and then back to New York, basically to conceal the origins of where this money was coming from. Count 6, from 2006 to 2008, related to that, similar type of activity, moving funds back and forth from New York to London. Count 7, money laundering. April 13, Madoff caused $54.5 million to be transferred from his firm's investor account in New York to another account in London. And the money was derived from fraud. Count 8, false statements. Madoff caused the filing with the SEC on January 7, 2008, a uniform application for investment advisory registration. He was applying to become registered as an investment advisor. And that application is false. The form falsely stated that his firm had custody of advisory client securities. Why was it false? Because they had no securities. And he was applying to become an investment advisor, saying that his firm had custody of these securities, when in fact they did not. Count 9 is perjury, that he lied under oath to the SEC, did not lie to federal officials. If you do so, there are specific criminal penalties. Count 10, false filing with the SEC. And count 11, theft from an employee benefit plan. September 24, 2008, Madoff stole $10 million in pension fund assets. This was a pension fund that invested with him, which was sent to his firm by a master trust on behalf of about 35 labor unions. This was a master trust that was formed to become the pension fund of 35 different labor unions. They sent in $10 million to invest through Bernard Madoff's firm, and this was the basis for alleging pension theft from a pension fund. Now, Mr. Madoff pled guilty to all 11 counts. Many of you may be familiar with the term plea bargain. What's a plea bargain? What was that? That's right. When a person is charged with a serious crime, a second-degree homicide, maybe he faces 25 years to life in prison, but he agrees to plead guilty to first-degree manslaughter, and the government recommends that he be sentenced to 15 to 25 years to avoid going to trial. By pleading guilty to a lesser charge, he gets a reduced sentence. This was not a plea bargain. Madoff pled guilty to all 11 counts, all 11 felony counts against him. There was no agreement on the part of the government to recommend any reduced sentence. And what happened was Judge Chen, the federal judge, imposed the maximum sentence on each count. And each sentence on each count was to run consecutively. Sometimes judges will impose sentences to run concurrently at the same time. Here, they're imposed one after the other. I'll just go down the list. Security fraud, 20 years. Count 2, investment advisor fraud, 5 years. Mail fraud, 20 years. Count 4, wire fraud, 20 years. Money laundering, count 5, 20 years. Money laundering counts, international money laundering, count 6, 20 years. Count 7, money laundering, 10 years. 8, false statements. 9, perjury, 5 years. 10, false filing with the SEC, 20 years. 11, stealing from the employee pension benefit plan, 5 years. Each one to run consecutively. That's the criminal proceeding. Mr. Madoff is now in federal prison and will be there, for the rest of his life. Okay. Any questions on anything related to the criminal proceeding? Let's talk about the liquidation proceeding and the bankruptcy. In December of 2008, right after this became public, right after Madoff went to his sons and they went to the authorities, the Securities and Exchange Commission, the SEC, started a civil action civil lawsuit against Mr. Madoff alleging various counts of securities fraud, civil claims. In that lawsuit, the Securities Investor Protection Corporation, SIPC, which is known as SIPC, applied to have a trustee appointed. What is SIPC? SIPC, Securities Investor Protection Corporation. How many people here know that if you go to a bank and you put in $5,000 in the bank account, you have an insured account? If the bank goes out, you get your money back. How many people know that? And what type of insurance is that called? FDIC, Federal Deposit Insurance Corporation. There's something similar in the securities industry. If you have an account in an investment, a brokerage firm, and you have $25,000 worth of stock in the brokerage firm, under the Securities Investment Protection Corporation, which was set up by a federal statute in 1970, Securities Investment Protection Act, you have insurance. Now, just be very clear you understand. It does not mean that if your stock goes down in price, stocks go up and down in price. So if your $25,000 goes down to $10,000 because the price of the stock dropped from 25 to 10, you don't have insurance for that. That's normal losses in the market. But you do have insurance if the brokerage firm goes out of business, they go into bankruptcy, or if there's some type of fraud, which of course is what we're dealing with here. If the broker or the firm steals your securities or committed some type of fraud, steals your money, you then can file a claim under SIPC, SIPC, to get your loss back up to a maximum of $500,000 per customer. So if you lose $10 million with a broker, Bernard Madoff or any other broker, and you file a claim under SIPC, and it's approved, and it's upheld, you can get back $500,000. This is paid through the fund that's maintained by SIPC, which all registered brokers and broker-dealers are members of and pay money into. Okay, now that was one proceeding that was started in federal court in Manhattan. The federal judge in Manhattan appointed a man by the name of Irving Picard, P-I-C-A-R-D. You may have heard that name. He's been a long-time bankruptcy trustee. The federal judge in Manhattan appointed Mr. Picard to be the trustee of Bernard Madoff Investment Securities Corp. What is a trustee? What is a trustee? A trustee is someone who is appointed, in this case appointed by a federal judge, to take over legal control, legal title and legal control of the investment corporation. All legal authority to handle, to manage, to make decisions on behalf of Bernard Madoff's company is now vested in Mr. Picard based upon federal judges appointing him under the SIPC law. We'll get to what he does in a minute. Now, at the same time that the SIPC proceeding was started, or a little bit later, I should say, Mr. Madoff filed a personal bankruptcy in bankruptcy court. And that bankruptcy proceeding, which is Mr. Madoff's personal bankruptcy proceeding, also was what's called a Chapter 7. There are various types of bankruptcy proceedings. Chapter 7 is when basically a person has more debts than they can pay. The court appoints again a trustee to take over legal title, custody of all that person's property, and to step in the shoes of that person. The bankruptcy court appointed the same man, Mr. Picard, to be the trustee in bankruptcy with respect to Madoff's personal bankruptcy. The federal judge transferred the SIPC proceeding to bankruptcy court. So now in bankruptcy court, you have a double proceeding, consolidated, joined together for certain purposes. The SIPC proceeding with respect to the company, and the personal bankruptcy with respect to Mr. Madoff personally. The purpose of both of these proceedings is to do what? What is the trustee now trying to do? Yes? Say that again, please. To liquidate all of his assets. For what purpose? That's right. To gather up all the assets that he could get, to liquidate, to sell them, convert them to cash, to establish a fund that then can be used to pay off claims that are submitted to the trustee, which he then has to approve or reject, and ultimately approved by the bankruptcy court. And if that goes according to the way it's supposed to go, there would be some monies available to pay people some portion of what they lost. In addition, this is in addition to the $500,000 that they might qualify for under SIPC. Now, the question becomes, how do you determine what each person's claim is worth? Here's what I mean. Suppose an investor with Bernard Madoff's company invested $10 million back in 1990. And over the next 18 years, periodically took out money from his account. Took out $15 million. So he invested 10. Over the next 18 years, because they were making money on paper, this particular customer takes out $15 million, but still has a balance. They still has a balance of 15, or let's say 12 million with the firm. And now, in November of 2008, right before this whole thing was exposed, the last statement, a copy of one of the statements was given out. The last statement shows that this customer has 15 million, 12 million sitting in the account. Is this person a creditor? That's a tough question. It's a tough question because you have to decide, how do you determine, the term here that's being used in court is the net equity. One method is cash in and cash out. Meaning what? This particular person invested $10 million. How much did he take out? 15. So he's $5 million ahead of him. He didn't lose any money. He may not have made what he thought to make, but he actually received $5 million more than he invested. He got back his $10 million and the $5 million. That's the cash in and cash out method. If that method is employed, many of Madoff's customers, who were customers as of November 30th, 2008, would not have a claim. Because under that method, they did not lose money. The second method that was argued in court that should be used instead of cash in and cash out was the last account statement balance. The last account statements that went out on November 30th, 2008, shortly before he turned himself over to his sons. In our example, the investor who invested $10 million took out $15 million, that $5 million more than he invested, would still have a might still have a $12 million balance on his account as per his last statement. The attorneys for these investors, or many investors, said that's the correct number. And that should be the amount of the claim. The matter was argued in bankruptcy court back in the spring, in March. The bankruptcy judge, Judge Lifland, said no. The correct measure here, the correct method to determine the claim is cash in and cash out. So our investor would not be a creditor, would not be someone who is owed money, would not be a claimant. Judge Lifland, through a procedural device, certified that question to the Federal Appeals Court in Manhattan. Obviously a very important question. Is this the correct method? Cash in, cash out? Or should it be the last statement method? That question is now before the United States Court of Appeals, very high federal appeals court, second only to the U.S. Supreme Court. And they will make that determination. They have not yet decided that question, which method is used. The method is very important because it impacts not only claims in the bankruptcy proceeding, but claims in the SIPC proceeding. It really depends on which method you use to define the class of creditors. And the trustee Picard, has a website. And on the website, he talks about this. And he gives two examples. He says if we use the cash in and cash out method, he is projecting that he will recover $6 billion in assets. That's what he's projecting that he will be able to recover. If you use the cash in and cash out method, he projects that the total amount of the claims will be $20 billion. However, if you use the last statement method, he projects that the total amount of claims will be $60 billion, much higher. Now, the way this works, if you file a claim, you would get a pro rata distribution based upon the amount that they recovered over the total amount of the claims. So if we use the cash in and cash out method, if the trustee recovers $6 billion, you divide that by 20 billion, which is the projected total amount of claims using cash in and cash out, that's 30%. So if somebody lost $1 million, they would have a valid claim to 30% of that $1 million, or $300,000. And they would be able to get paid the $300,000 on the SIPC, up to $500,000. However, if you use the last statement method, computation is different. Now it's 6 billion over not 20 billion, but the projected total of the claims under the last statement method is 60 billion. So instead of 30% payout, it becomes 6 over 60, 10%. So our same claimant now doesn't get 300,000, he gets 100,000. So this is a very important question. Question in the back? Financial statements were wrong, but the attorneys in court argued they're the victims. They didn't commit the wrong. They had this is the argument, that they had every reason to believe that this was the amount of money they had, and they didn't do anything wrong. The bankruptcy judge rejected that argument. He said, look, we got to look at the cash you put in, the cash you took out. And in the example I gave you, you're not a claimant, because you took out $5 million more than you put in. So we'll have to wait and see when the Second Circuit Court of Appeals decides. It could be any day. And probably there's a good chance that that decision will then be appealed to the U.S. Supreme Court. Now, there's another aspect to this. And we'll get into this in a minute when we talk about the other lawsuits that are pending. If you reject the notion that a person that put in $10 million and took out $15 million is a creditor, is a claimant, right? The state doesn't owe him anything. The trustee is taking the position that he could sue these people. The trustee could sue these people for at least the $5 million they got paid over their $10 million investment. And maybe even the $15 million, on the theory that everything should be brought into the fund. So not only, if you use the cash in and cash out method, will a number of people not be creditors, not have a claim, they're going to find themselves being sued by the trustee to get, this is called clawback proceedings, where the trustee is trying to get money back into the estate from people that should not have been paid this money. Legally, they're known as avoidance actions, where the trustee in bankruptcy, through various provisions of the bankruptcy code, and under SIPC as well, has the authority to go after people who were paid money by the bankruptcy debtor, in this case the firm, money that they should not have been paid. If they weren't paid this money, that money would still be in the firm and would now be available to the bankruptcy trustee. So it's a very important question. It defines who's going to be the creditor, but it also defines who's going to be sued. Now, the bankruptcy proceeding is also going on. Madoff's personal bankruptcy proceeding. And the same as the Picard's the trustee. And his job is basically the same. Gather up the assets, sell them, establish this fund, create this fund, which then could be used to pay out to the creditors. What happened last weekend? Anybody remember hearing it on the news? It was much publicized. They had an auction. All sorts of personal property of Mr. Madoff, probably many items that belonged to Mrs. Madoff that I think she just agreed to let go. And people paid all sorts of money. Just to give you an example, Mrs. Madoff's engagement ring was bought at auction for $550,000, okay, by somebody who's unidentified. Somebody paid $6,000 for a lot, a collection of property that contained Madoff's slippers. Another lot made up of unused boxer shorts and socks, sold for $1,700. No comment on any of this. But this money will go into this fund that the trustee is building to hopefully be used to pay off the creditors pro rata. Questions? Now let's go, yes?
It seems like this actions was premeditated, right? But
Yes.
in terms of like his wife and his sons, like probably juggle money around. Does the government have do they have legal right to that?
Yes. There's been no further criminal actions brought against these other people, but there are a number of lawsuits that have been brought by the trustee against various other people, including Madoff, some of his relatives, and his wife. And we'll get to that in a minute. Let's go back to SIPC. Proceeding where people who lost money with Madoff might be able to get $500,000 per person, per customer. In order to qualify under SIPC, you have to have had an account with a registered broker-dealer. Broker-dealers have to register with the SEC. As was pointed out, many of the feeder firms that fed money into Madoff's firm were hedge funds and other types of funds that would not register. Now, you have to go back to the days of President Clinton. The securities laws were liberalized. And basically, there are, 1996, I believe it was, amendments were made to the Investment Company Act of 1940. And if you invest in a firm where the investments are held by less than 100 people, or if you invest in a fund or a firm where there's no limit to the number of people, but each investor is what's called a qualified investor, meaning very wealthy, meaning individuals who have at least $5 million in net worth. If they have at least $5 million, you add up their assets, subtract their liabilities, and they have at least $5 million, or companies that have more than $25 million. If a fund has those types of people for their customers, the fund can have any number of people. In either case, less than 100 or qualified people, the fund does not have to be registered with the SEC. So let's take somebody who invested $20 million with a hedge fund. And the hedge fund then turns around and invested that money with Bernard Madoff. Who was Bernard Madoff's customer? The hedge fund, not the individual who put up the $15 million. Can that individual now file a claim under SIPC to try to get back $500,000? The answer is no. Why not? They didn't, and who did they invest with? Right, and they invested with this fund, which was not registered. So these people are out in the cold. They're not going to be able to recover under SIPC. They may be able to, and this has to be determined yet, but they may, and I think they will be able to recover in the bankruptcy proceeding, because there's no similar limitation there. Okay, so I mentioned the third part of what I'd like to talk about, all these lawsuits. The trustee, Mr. Picard, has brought a number of lawsuits against various people. And I think it's somewhere in the neighborhood of at least 17 in one category and various others. The purpose of these lawsuits basically is to get money in the hands of the trustee's funds to be used eventually to pay off the creditors. The trustee has brought, I believe, as of the end of September, 17 avoidance actions, going after various parties, trying to avoid, set aside, payments that were made to them by Bernard Madoff's company within a certain amount of time before the end, under various provisions of the Bankruptcy Act. These are called avoidance clawback proceedings, where they are trying to get this money back into the estate. He's also brought actions against 4 family members, Peter Madoff, Mark, Andrew, and Shari Madoff. I think there was his brothers and his sons, I think. There's also a lawsuit pending against Ruth Madoff. I know they had tried to settle it. I don't think that's been settled. That's progressive. They also have various lawsuits against Madoff-related entities. Madoff had set up a number of various companies, different types of investments, which technically were not brought into the bankruptcy proceeding or the SIPC proceeding. The trustee is suing a number of these entities. The trustee is involved in many other different types of lawsuits. For example, some people directly, some people who lost money with Madoff, they went and they sued feeder funds themselves. Well, the trustee says, wait a second, if these potential creditors out there are suing the people that I want to sue, that's going to interfere with my ability as a trustee to conduct this bankruptcy proceeding. So the trustee goes into bankruptcy court. Bankruptcy court has tremendous power. And the bankruptcy judge issues injunctions. What's an injunction? A court order directing someone to do something. In this case, the bankruptcy court issues injunctions against the various people who have brought these lawsuits against potential defendants in avoidance actions. So you can't, stopping them from going ahead with their own lawsuits, because the trustee wants to go against these people and get the money for everybody, all the creditors. So there are a substantial number of lawsuits that the trustee is involved in. There was one lawsuit that the decision came down at the end of October. The Federal Court of Manhattan, the Appeals Court, issued a decision. How's this for bad timing? An entity called the Rosenman Family LLC, probably set up by a wealthy family to be the vehicle for their investments, set Mr. Madoff's company $10 million sometime after November 30th, 2008. Remember, this all came out. In fact, he went to his sons December 12th. Days before this was exposed, this particular investment fund from a family sent him $10 million. They didn't even have a statement because it was after the last statement. Their attorneys went into court and said, wait a second, we get our money back. We're not customers. We didn't even invest in anything. We talked about possible investments. We got no statement. The money was sent in. We talked about what we might buy. Give us our money back. You know, we don't have to go through this whole proceeding in SIPC, maybe to get $500,000, or file a claim in bankruptcy to get a certain percentage. We should get our $10 million back. He stole this money from us, and it wasn't invested. Bankruptcy court said no, said you were customers, and this money belongs to the estate. It's a tough pill to swallow. Went up on appeal. The appeals court said, we cannot decide at this point if you're actually a customer. We have to wait for further proceedings. But they agreed that the $10 million belongs to the estate. So these people lost. They're basically going to be thrown in with everybody else. And this was days before this was exposed. Just the other day, they announced they sued various employees of Madoff's firm. That was just announced 2 days ago. The trustee was going after, he named 4 employees that were involved in, I believe, receiving the money, monies that came in, and paying out money. So he is trying to go after as many people as he can. Professor Marola, I think, made a point about the lessons that we can learn from this. And I think the lesson that Professor Marola said is very, very important. And I'd just like to leave you with this. If somebody comes to you with a proposition, an investment, and it just seems like it's too good to be true, the answer is it's probably too good to be true. There's no free lunch out there. Somebody promises enormous returns. You ask hard questions. I have been an arbitrator in Wall Street, the New York Stock Exchange and the NASD, and now for FINRA, where people have claims against brokers. And I've done this for over 20 years. And many of the cases I've been involved in where customers would sue brokers. And in many of these cases, nothing compared to Madoff's case in size, but in many of these cases, the broker would promise all sorts of great returns. And most of the time, there's something wrong. So if somebody makes these promises, you really look at it hard and fast. Ask questions. Professor Marola pointed out, Madoff is good. Because if you ask him questions, what would he do? Throw you out. And you want to be in the club. You don't want to be thrown out. You want to get these returns. If that's the case, quit. Take your money out. If a professional is not willing to answer your questions, don't deal with it. Now, the thing that was really, Professor Marola and I were talking, we couldn't understand how this could happen. We didn't understand what the statements looked like. We found this statement on the internet that was circulated. And at first I thought it was a very summary type statement that he would use, but no, it's a fairly detailed statement. Bottom line is, if you do an investment with a brokerage firm or some type of investment company, and you get a statement every month, look at it, read it, study it. If you have any questions, get those questions answered. And I'll tell you something else, don't just go back to the broker. Especially if you're dealing with less than a very large established firm, and even those firms. Go to somebody that you have confidence in, accountants, lawyers, friends who have experience. Let them answer those questions for you. It has to make sense to you. I've been involved in many cases where people got statements and never looked at it. Or if they looked at it, they looked at 2 things. What 2 things? What balance? That's exactly right. Starting balance and the ending balance. And as long as they were making money, they could care less. When they started losing money, then they went to their accountants and they went to their lawyers. But don't do that. Look at those statements. Make sure you understand what's on there. Questions? Thank you.
I have a question for you before you go. Do you think Mr. Madoff, when he started his firm, planned to do this fraud? No. He admitted after he was convicted and just before sentencing, he said, no, it just accidentally happened. Something I wanted to say that. And the other thing I just wanted you to know, even with the feeder firms that gave him the money, he played off of their greed. In the commission split, he was giving them as much as 90% of the commissions. So they were like, if I get X commission, they were getting the whole pie, so they would more so come to him. So it further continuing the money coming in because of the large commission structure. So I just thought that there are a couple of videos. Could you put the one? I just want to show you a video that. So hold on one second. I'll help you out here. It's right here. I think you go like this. Oops. 1 second. First play.
It may take months for investigators to fully understand Bernard Madoff's $50 billion Ponzi scheme, but friends and investors from Hollywood to Palm Beach, Florida, may never be able to reconcile the man they knew with the scam he's alleged to have run.
When my wife's sister passed away, Bernie Madoff came to the funeral. That's the type of individual that we all thought he was, a very caring individual.
Norman Brayman, former owner of the Philadelphia Eagles, invested with Madoff and says he never appeared too eager to accept new money.
You had to know somebody, a friend of a friend, who had some influence for Madoff to accept an account. I mean, this was a classic scam.
Though he socialized with a wealthy set, his own lifestyle wasn't overly lavish.
He didn't live a flamboyant life. He didn't have a big fancy yacht. It was a combination of factors: what he looked like, his manner, his supposed record, the fact that he was a philanthropist.
This was a huge punch in the stomach. It's a personal punch in the stomach because this is somebody I knew and still have affection for.
Francis Levy is the director of an educational center that had virtually all its funds invested in Madoff securities. He says the deception is hard to believe.
Is it possible that he is a sociopath who cares nothing about human beings? And I can't believe that.
All right. Well, we are joined by Michael Santoli from Barron's Magazine. Michael, good morning.
Good morning.
So how did he get away with it for so long?
Well, it seems one reason he got away with it is that investors didn't have any losses to complain about. His returns seemed good. There was no dissatisfied investors. As folks there said, he actually cultivated this sense of privacy and exclusivity. He made it hard for you to get in, and therefore it wasn't a typical money manager who said, give me all your cash, I want to run it. And so I do think that the SEC oversight, certainly there were lapses there. This is a firm that was examined numerous times without anybody finding anything, but it seemed as if there was no smoking gun. There was not a lot of complaints about him.
Well, what about like the hedge fund clients? I mean, the people in the financial world, how did they get fooled?
Well, there really is not a good excuse for those folks getting fooled, in our opinion. I mean, Barron's 7 years ago raised some questions about the unusual supposed predictability of his returns, the fact that he was so private, the fact that he insisted on privacy from his clients. And what you'll notice is it was not a lot of big state pension funds, for example, that would have a very rigorous kind of vetting process. It was hedge funds who were looking for steady returns, not, by the way, mind-bogglingly high returns, just steady ones, and consistency and no losses. And they were essentially looking to glean fees off of their client accounts by giving it to Madoff. It was really just a convenience matter.
How much blame should the SEC be taking in all of this?
Well, I think plenty of blame. I mean, obviously, by the SEC's own apparent admission, they clearly feel like they should have caught more of this. But I don't know that it would have been possible to necessarily nail him at an early stage here. If somebody is committed to committing fraud, and if they want to bring new investors to pay off existing investors, which is what a Ponzi scheme is, that game can go for a long time before people notice it.
So are are you telling me there is no way we can put regulations in place where future investors won't get fooled?
I don't think that we need new regulations. We need the examiners to actually be more rigorous about going in there and making sure these accounts contain the securities that the manager says they contain. That seems to be a very simple thing that wasn't followed here.
And in the final seconds, the biggest takeaway message or lesson learned in all this is
if it seems too good to be true, it probably is. And his returns did seem too good to be true for too long.
No more questions? Okay, thank you all for coming.